My name is Joel Shiver. From June 2004 until August 2012, I was the Circuit Public Defender for the Northern Judicial Circuit. Under the Indigent Defense Act of 2003, my office was charged with representing indigent criminal defendants in the superior courts, as well as juvenile defendants and delinquency actions in the juvenile courts of the Northern Judicial Circuit. We also contracted with Elbert County for representation in criminal actions in state court. Further, we contracted with the 5 counties of the Northern Judicial Circuit to provide representation in deprivation actions, where the state is seeking to remove children from their parents' custody. I do not presume to speak for any of the public defender. The Northern Judicial Circuit is in the northeast section of the state. There are 5 counties and a number of small towns. The Northern Judicial Circuit is a rural circuit with a poverty rate of 17%, slightly higher than the state average of 14.7%. The population density ranges from 29 people per square mile in Oglethorpe County to 99 in Hart County, with an average of 70. The office is in Royston, about the middle of the 4 busiest counties. I had an incredible team of 12 dedicated employees. The staff included 7 lawyers, including myself. 1 lawyer is assigned to the Superior Court in each of our 5 counties. I handled juvenile court in all 5 counties, and there is 1 paralegal who is also a lawyer, but who prefers to not be engaged in the active practice of law. There were 2 investigators who are each former law enforcement officers with many, many years of experience, and 3 support staff. At the conclusion of this presentation, it is my hope that you have come to understand how anybody doing this work cannot help but become committed to it. What we want to do here is take a look at the numbers of prosecutions brought in the circuit, and then we'll explore how those numbers affect the criminal justice culture of the Northern Circuit, including 1, severely backed up criminal dockets, 2, low conviction rates at trial, and 3, increased numbers of conflict cases. Underlying all those problems is the trend represented by this graph. The number of cases brought in the superior courts in the Northern Judicial Circuit almost doubled from 2004 to 2008. We'll also look at the trend in the succeeding years. The dramatic increase in the number of cases can be attributed in part to the citizens' demands that we get tough on crime. To that end, those citizens have made it their duty to provide extra money for law enforcement. These are just a few examples of websites law enforcement can go to get grant money for making cases. The availability of this grant money gives law enforcement a financial incentive to make cases. When I first took this job in 2004, to fairly apportion each county's pro rata share of their funding for the office, I started gathering the numbers for the cases brought in Superior Court. This chart reflects the numbers in each county sorted by year. The first year I got information on was 2003, and you can see that there were a total of 1,248 cases brought in the circuit that year. You can also see that those numbers almost doubled between 2003 and 2008, when there were a total of 2,040 cases brought in the superior courts of the circuit. I have no explanation for that increase. It is unlikely that actual crime in the counties increased to that extent, but it is perfectly obvious that more cases are being brought. Another fact that this chart shows is that 2 counties in particular are leading the increase. Franklin County, shown here in red, and Madison County, represented in purple. We'll take a brief look at each county in the circuit individually in a moment. In this graph, I have separated the areas to show the individual counties. Again, Franklin and Madison counties show the highest numbers. It is true that Elbert County is one of our more populated counties, and they have high numbers as well. But Elbert County has a separate state court where the misdemeanors are prosecuted separately. This chart does not reflect the numbers for Elbert County State Court, but as I mentioned earlier, we contract with Elbert County to provide representation in state court for an additional fee, a fee which helps reduce the cost of the remaining 4 counties. This next series of graphs shows the trend for each individual county. The first is Elbert, which, as you can readily see, apart from the dramatic increase from 2004 to 2005, has remained relatively consistent over the years. I have no explanation as to why Franklin County saw such a surge from 2005 to 2006, or for the decline from 2008 to 2009, and then the jump from 2010 to 2011. Hart County also saw an increase from 2005 to 2008. The recent trend in Hart County has been back toward their numbers from 2003, 2004, and 2005. But something very dramatic happened in Madison County. In 2005, Madison County had 224 cases in Superior Court. The Assistant District Attorney for Madison County told me that when he took that position in 2006, the first thing he did was to go to Magistrate Court and pull all those warrants that were about to expire under the statute of limitations and file them in Superior Court. Consequently, there were almost double the cases brought in Superior Court that year, 421 in 2006. And for some reason, there was another dramatic rise in the cases brought from 2010 to 2011. There are a number of problems associated with prosecuting old warrants. First, the evidence is likely grown stale or it's gotten lost. Further, witnesses may die or move away. Police officers can also move away. And there is an additional matter to note as well. It is not unlikely that those warrants had not already been accused because the case itself may be weak and not worthy of the time and money to prosecute. Here's an example of what a poor case is. The police stop a car with 4 occupants. They search the car and find a small bag of pot in the glove compartment. They arrest all 4 people. My client is sitting in the back seat behind the driver. Not only will they not be able to prove the case against my client, they've created 3 potential conflict cases. The same dramatic increase that happened in Madison County also happened in Oglethorpe County. When the ADA took that job sometime in 2007, he started accusing those old warrants, and from 2006 to 2008, Oglethorpe County saw the number of cases nearly double, from 196 to 352. Here's an example of how prosecuting a poor case wastes everybody's time and money. My client was a known local drunk charged with public intoxication. A law enforcement officer had seen him walking drunk down the side of the road. He picked him up and took him home and told him to stay there. 30 minutes later, the law enforcement officer saw him walking down the side of the road again. He picked him up again and took him back home. 30 minutes later, the same thing. Only this time, the law enforcement officer took him to jail. He slept it off and got out the next day, and that should have been the end of the matter. However, the ADA made a Superior Court case out of it. First of all, it was not public intoxication. To be guilty of public intoxication, you must appear in and be in a state of intoxication is made manifest by boisterousness, lewd behavior, or profane language. Walking down the side of the road drunk is not one of those public intoxication cases. None of the elements were present here, neither in the officer's incident report nor in the accusation. I pointed this out to the ADA and suggested he may want to dismiss the case. He refused and offered my client probation. I tried to get the ADA to look at the statute. He refused to even talk to me about the case. They finally dismissed that case some months later, but not before we had wasted a whole lot of time arguing about it, time that would have been better spent in resolving more important matters. And there's no shortage of those cases. Another factor leading to the increased number of indictments is demonstrated in the following few slides. This is from the August 12, 2009 Elberton Star. There were 121 true bills and 3 no bills. From that same paper 25 years ago, 35 true bills, 14 no bills. Here's what it looks like graphed. And here's that difference expressed as a percentage, and this is why it is significant. If a prosecutor is uncomfortable in exercising his discretion to dismiss a court case, he can present it to the grand jury. He can explain to them the facts and the law and what he thinks about the case and let them decide. That's the grand jury's job. If they feel that it's not worth wasting the court's time and the county's money, the grand jury can no-bill it. A drop from 35% no bills to 2% no bills indicates that that is not happening nowadays in the Northern Circuit. Most of the work we do as public defenders involves working out plea bargains with the prosecutor. The United States Supreme Court has noted that plea bargains have become so central to the administration of criminal justice that defense counsel have responsibilities in the plea bargain process that must be met to render the adequate assistance of counsel that the Sixth Amendment requires. Here's how a backlog of cases on the docket hinders our ability to plea bargain with the DA. The private bar loves it. Their best strategy is to have cases linger. As I mentioned earlier, the evidence can grow stale or get lost. Witnesses may no longer be available. If you want a Cadillac defense, hire your own lawyer. But a public defender's office with its high caseload has to move cases. In that regard, we strive to provide a solid, dependable Chevrolet defense. To move cases, we have to be able to have an intelligent conversation with the DA about the relative merits of a case before we can negotiate an appropriate plea. If the DA doesn't know his case, we cannot get the case resolved. Not being able to resolve cases results in a tremendous waste of the court's time and the county's money. Moreover, when the DA doesn't know his cases, the chances increase that an innocent person may be convicted, and likewise, that a guilty person will go free. This is an example of how cases can linger if we're not able to reach a timely resolution. My client was a UGA student, and he and three of his roommates were charged with growing marijuana. The police had gotten a tip that they were growing a few marijuana plants in a flower pot in the house they rented. The police obtained a search warrant and found the burnt nubs of a couple of plants. They charged all four students with manufacturing marijuana. My client had never been in trouble and was a good student and a decent kid. The DA's offer was 10-6. That's 10 years with the first 6 in prison. Incredulous, I asked the assistant district attorney, "Have you looked at your case?" "No." For 18 months, that kid went around with the specter of 6 years in prison clouding his life and goals. We finally pled him to 6 months probation. More bad consequences. When calendars get backed up and we can't get cases resolved, many of which should not even be there in the first place, one of the consequences is increased conflicts. Here's how that works. Remember that guy I talked about earlier who was charged with public intoxication? Had he been the victim of an aggravated assault while his public intoxication case was pending, conflict counsel would have had to have been appointed to represent the fellow charged with a much more serious aggravated assault. Again, a needless waste of the court's time and the county's money. But there is an even more expensive consequence. Let's take a random snapshot of the outcome of a number of trials spanning 2009 and 2010. The blue in this chart delineates the cases tried by my office. The pink shows those tried by conflict attorneys, and the white is for retained lawyers, those who were paid by their clients. During the 13 months from August 2009 until September 2010, there were a total of 35 trials. Of those 35 trials, there were only 10 convictions. These convictions are those you would expect to see: aggravated assault, burglary, murder, etc. But there were 21 not guilties, 2 dismissals, and 2 mistrials. Now, in addition to the sheer number of not guilties, which include aggravated child molestation, armed robbery, murder, look at this first case here from August 2009. Kidnapping, child molestation, false imprisonment. bring your attention to the top right corner. Hart County paid for a courtroom full of jurors to come in. They picked 13 to return the next day. The state puts up their first witness. Defense counsel does its cross-examination. The state then promptly dismisses the case. And another down here on the right and in the middle from March of 2010. Hart County paid for this room full of jurors to come in, and the lawyers picked a jury. After jury selection, the state dismissed the case. At least Hart County realized the savings of not having to pay the 13 jurors to return the next day to hear the evidence, as well as the salaries for the various court personnel, for example, bailiffs and court reporters. This chart details the district attorney's conviction rate for that time period, and I might add, things do not seem to have improved since then. Of the 35 cases that went to trial, 26 involved indigent defendants. Our system of justice, to work as well as it possibly can, demands that everybody involved in the process does their job as well as they can. That includes police officers from the initiation of the case, prosecutors, grand jurors, traverse jurors, defense lawyers, and judges. I suggest to you that this chart reflects the fact that the Public Defender's Office did their job. There's one more thing to note when considering how the prosecutor's inability to know their cases results in needless waste of the court's time and the county's money. Judge Hodges is fond of accusing the Public Defender's Office of never being ready for trial. One day, trial was set for an insurance fraud case in Madison County. That was the only case to be tried, and Madison County paid for a courtroom full of jurors, as well as the bailiff, court reporter, and the other personnel for that just that one case. My chief assistant is Jana Jacobson, and she is assigned to handle Madison County. The week before the trial was scheduled to start the next Monday, I had hired a new lawyer for Franklin County. Her name was Leslie Carden, and she had 25 years' experience as a lawyer, much of that in indigent defense. Jana and Leslie were discussing Jana's insurance fraud case, and Jana mentioned that she'd been provided in the discovery materials from the DA's office only one document from the insurance investigator's office. Leslie remarked as to how that was odd, because when an insurance investigator's office is involved in a case, they usually have a box full of documents. In any event, Monday morning rolls around, and Jana arrives at the Madison County Courthouse to try the case. Sitting there on the back row of the courtroom is the state's witness from the insurance investigator's office. Sure enough, he's brought with him a box full of documents. Upon discovering this, Jana comes forward and asks Judge Hodges for a continuance. There's no way we can provide effective representation of our client without reviewing the state's evidence. It is the duty of the district attorney to turn over this evidence during the discovery process, so we'll know what we'll be up against in trial. After Jana asked for the continuance, the DA announced that he didn't need a continuance because he felt he could proceed to trial on the one document he had provided to us. Judge Hodges denied Jana's motion for a continuance. I was there, and I witnessed this because I'd taken my new lawyer, Leslie, down there to introduce her to Judge Hodges. After Judge Hodges denied Jana's motion for a continuance, I approached the bench to introduce Leslie. Before I could say anything, Judge Hodges said to us, "The thing I don't like about the Public Defender's Office is that they are never ready for anything." I let it go, as I was used to Judge Hodges leveling these inappropriate and inaccurate accusations against my office. While Leslie and I were at the bench talking with Judge Hodges, the assistant district attorney was talking to his witness from the insurance investigator's office. After we stepped away, the ADA came forward and told the judge that they needed to put that case off because he needed time to review the documents. Judge Hodges granted his request. Keep in mind, it is the DA's job to know what the evidence is and to provide the defense attorneys with that evidence at least 10 days before trial. The DA didn't know his case, and Madison County footed the bill for all those jurors and courtroom personnel to show up that day for that one case, only to not be able to get anything done. Not getting served with timely discovery is a matter that occurs over and over in the circuit because the DA has not had adequate time to look at his case. When we complain about being surprised with new evidence on the day of trial, we are invariably blamed for not being ready. What makes this abysmal conviction rate we're looking at here even more appalling is this fact. The DA's office controls what cases get put on the trial calendar. If the DA's office is not ready to try a case, they simply don't put it on the calendar. However, given that their caseloads are so heavy, because, as has already been shown, there are so many poor cases crowding the docket, the DA most often is not even aware that they're not ready to try a case. And that's what happened in the example of the insurance fraud case I just described. That's why the conviction rate is so low. We waste so much time arguing about poor cases like the public intoxication case I described earlier. There's little time left to take care of the business that really needs seeing to. This results in a significant waste of the court's time and the county's money. And a final note on this conviction rate. The Northern Judicial Circuit is an extremely conservative rural circuit. Conservative venues are not known for juries favorable to the defense. That the DA's office has only managed a 29% conviction rate overall, and a prosecution-friendly jurisdiction simply highlights the problems in that office. The Indigent Defense Act mandates that the counties provide the office supplies, utilities, and phone for the local public defender office. It also gives counties the option to provide additional funding for local personnel. There exists a disparity among the judicial circuits in the state to pay for providing the additional staff needed to meet the constitutional mandates of effective representation under the Sixth Amendment. Pursuant to the Indigent Defense Act, there's a formula to determine the positions funded by the state. The state funds a number of positions based on the number of Superior Court judges in the circuit. The local counties provide the funding for additional positions. In most circuits, this funding amounts to 40% of their budget. The counties in those circuits provide the additional 60% of their funding. Here you can see that the Eastern Circuit actually received 67% of its budget from local funding and 33% from the state. In other words, the Eastern Circuit gets $1 million from the state and $2 million in local funding. In the Northern Circuit, it's just the opposite. 63% of my budget comes from the state. My counties provide 37%. For my counties to bring their contributions up to the state average, they'd have to almost double what they provided me every year. I'd get in excess of $350,000 additional per year over what they currently fund me. I was not asking for more money. I only want my counties to understand that I was able to provide excellent quality service at a substantial savings to them. Still, having said that, the office would better function with another lawyer so that the director could focus on his managerial duties.